Okay, so today we're going to start our discussion of registration. Before getting into intent to use, what we'll call ITUs, and use as a mark, I want to mention that big platforms like Facebook, Amazon, and Google often require a registration before they'll act on your complaints of trademark infringement, which encourages people to register who might not have in the past in the United States. Amazon in particular has had really significant effects on the trademark registration system by providing special benefits on its platform to sellers who have registrations in the US. Benefits that assist them in placement in Amazon search results, not just in fighting infringement. That sounds like a win-win, but note that those benefits on the Amazon platform don't require the putative trademark to actually do any of the things that we've said trademarks do for humans, which is why you get these strange six-letter combinations you may have noticed on Amazon. Annual PTO applications estimated to originate with small businesses have doubled since Amazon's brand registry began, from about 100,000 to 200,000, increasing the proportion of filings from small entities about 30% to about 40% annually. The goal for the next few classes are to understand the registration process and to train your judgment with lots of examples so you can recognize issues with a specific mark. The repeated theme is that careful attention to the legal requirements can provide significant advantages. One might describe this as manipulating the system, and sometimes it is, but that very much depends on what you think about how much trademark should be consumer-focused versus how much it should be producer-focused. Registration is very much about protecting the interests of producers, even when the geographic scope or priority dates of the registration don't correspond to actual consumer understanding. The first registration in the US was for paint. The first Czech and British registrations were both for beer. The United States is truly a commercial and a Puritan nation. A few points to focus on as we talk about the registration process. Applications to the United States PTO are submitted to a trademark examiner. If she refuses to register the mark, the applicant can appeal to the TTAB, the Trademark Trial and Appeal Board. A final refusal was reversed in about 19% of merits decisions overall in the past 10 or so years. If the applicant loses at the TTAB, she can appeal straight to the Court of Appeals, to the Federal Circuit, or to a federal district court. The district court can hear new evidence and engage in de novo review of the facts. The Court of Appeals must uphold factual findings if they're supported by substantial evidence, but determines the law de novo. Back to the examiner's part. If the examiner allows the mark, it's published in the official gazette of the PTO. It's very important for companies with valuable marks to monitor the official gazette to discover any pending marks that might threaten their own marks. Trademark owners who believe the proposed mark is likely to cause confusion, or in the case of famous marks, dilution, can oppose the registration before the TTAB. The supplemental register is for descriptive terms. These are terms that might be or might eventually become marks, but you didn't show secondary meaning. And it's not just terms. It can be a device, an image. The law is clear that registration on the supplemental register isn't an admission that the mark lacks secondary meaning. You might have a protectable mark, but simply have failed to prove the secondary meaning in front of the TTAB. However, registration on the supplemental register is an admission that the mark is not inherently distinctive. The TTAB says you're stopped from arguing otherwise. The U.S. is part of the Madrid Protocol, which allows foreign mark holders to apply for U.S. protection by finding a central application with the World Intellectual Property Organization, WIPO. And U.S. mark owners can do the same thing with respect to other countries. Very few U.S. trademark owners use the Madrid Protocol, though its use is increasing internationally. It can be lower cost if you're filing in many countries. The threat of central attack, that is, an attack at WIPO, is the greatest risk. If you lose your Madrid registration, you only get the rights you can acquire in individual countries. But only 2% of international registrations are withdrawn due to central attack. The basic standard for registration in the US is you can register a trademark if it is inherently distinctive or if it has acquired distinctiveness. By far, most registered trademarks are registered on grounds of inherent distinctiveness, that is, in the 85% range year over year. Unless there's an opposition, the registration process is ex parte. It doesn't involve a lot of independent investigation. For example, the PTO requires specimens of use, but it does not consult a lot of outside sources, and it doesn't conduct a lot of factual examination. As you saw in the example from previous classes, Cisco's iPhone, the PTO relies on the integrity of submissions, although the PTO has noticed that there's a problem of fraud in the creation of specimens of use. One result is that there is now an additional requirement for filing beyond those discussed in the text. A foreign applicant now needs to have a U.S. attorney. This has created a follow-on need that didn't exist before to distinguish between foreign and U.S. applicants. And the PTO has not entirely figured out how this can be done. Also, since the text was written, the PTO has decided to phase out paper filings. All filings are now electronic. Eventually, they won't even send out the paper registration certificate with its pretty gold seal, but you can order one if you want. As we mentioned last week, you do have to identify the class of goods or services divided into broad categories on which there's some international consensus. Then you identify what you're actually doing within the class. You saw a bit of that in the iWatch case where the application identified 30 specific goods. Many other nations don't require this second level of specification, which is one reason foreign applicants are notorious for listing dozens of goods and services that they don't really have a bona fide intent to use the mark on. A single acceptable specimen of use in each class will suffice to get the registration issued, even if you're claiming multiple goods or services. Affidavits of continued use are then required between the 5th and 6th year of the initial registration, and then renewal every 10 years. What that means is that the first renewal will be 10 years after the initial registration, not 10 years after the affidavit of continued use, annoyingly enough. The PTO recently started asking a random sample of registrants who were renewing their registrations, who normally have to submit only one specimen per class, to submit proof of use for 2 additional goods or services per class. If they couldn't, the PTO inquired further. In about half of those audited registrations, the registrants failed to pass the threshold proof of use requirements, resulting in either deletion of some goods or services from the registration, that was in 34% of the cases, or cancellation of the entire registration in 16% of the cases. So what that means is there's a lot of deadwood on the register. This is now a permanent program, but it's still just a small audit program. It covers only a small percentage of renewals. When the PTO audits registrations that weren't filed based on actual use in the U.S., that is, registrations that issued as a result of ITU and foreign extensions of protection, many of those had between 70% and 90% of the goods or services that had just been included in a Section 8 renewal, permanently deleted by the registrant. So as a scare tactic, the audit looks like it's really effective. But also, it's maybe not great that the office needs to scare anyone about this stuff. Some statistics about renewal. Of the over 130,000 registrations issued in 2003, about 47% were maintained in 2009 by affidavits of continued use. So about 50% seems to be the rule over time. Of those survivors, more than half, 60 to 70%, renew at 10 years, meaning that if you make it to 6 years, you are more likely than not to make it to 10. Use-based registrations are the most likely to renew, followed by ITUs, followed by international registrations that didn't have to show use at all. These surviving registrations represent about a quarter of the application cohort and a third of the registered subset. So I'm going to introduce now the final piece of the puzzle, which is intent to use. ITUs decisively changed the prior rules by allowing people to acquire priority before use. This began in 1988 when Congress introduced ITU applications at the same time as it tightened the definition of use in commerce. Congress wanted to eliminate token use. The result was that the new law lowered the threshold for filing an initial application because use was no longer required, but tightened the ultimate standard for registration by insisting on bona fide use in commerce, except for marks using foreign registrations as a basis for registration. The law also fixed the priority date as the date of the application, conditional on the application maturing into an actual registration. We also got special rules on assigning an ITU application. You can't assign an ITU application without assigning the underlying business. This is in order to prevent gaming the system. Often it might be cheaper to pay an extortionist who has an ITU than to challenge their good faith. The anti-assignment rule makes that transaction useless and thus decreases the incentive to be an extortionist. The extortionist now no longer has a worthwhile asset. The pros of an intent to use system are that it decreases the risks of adopting a new mark, and relatedly, it eliminates the token use system, which caused a lot of uncertainty because you couldn't quite tell ever what was going to be good enough. It also discourages stockpiles of marks based on token use. You may remember that P&G had no problem maintaining its registrations for marks in the minor brand program until there was litigation. P&G had to file statements of use every few years, but the PTO doesn't investigate the facts underlying the statement of use. So the marks remained on the principal register, scaring off potential competitors until someone came along who had the resources and the incentive to litigate. It also protects applicants, the ITU system protects applicants against people who commence use in good faith subsequent to the filing date of the application, thereby destroying the possibility of obtaining nationwide rights in the mark. So an ITU system would have solved the Zazu problem for L'Oreal. The cons, though, are also present. The system does cause some deadwood. There are about 50,000 statements of use filed each year, making up roughly 40% of the registrations issued. At the same time, over 100,000 ITU allowances are pending statements of use. Those marks are still unavailable before the allowance expires. About 75% of ITU applications are published for opposition. That is, the examiner approves them, and absent opposition, all the claimant has to do is file an acceptable statement of use to get their registration. But half of those published marks fail to be registered because of failure to file a statement of use. So that suggests that there are over 50,000 marks unavailable right now, even though they're never going to be used. If you contrast that, the registration rate for use-based applications, it's about 75%. It's twice as large. Another way to say it is that ITU applications comprise the majority of new applications, but use-based applications remain a majority of issued registrations, reflecting the significantly higher abandonment rates for ITUs. In addition, registration is still not mandatory, so trademark searches and ITUs don't provide completely reliable protection from earlier common law prior users like Zazu. Finally, establishing some of the bars to registration, especially likely confusion with an existing mark in opposition proceedings, becomes more hypothetical without use because you can't see the context of the use. So we will explore many of these details when we discuss the issue in class, and I will see you then.